Welcome to Hull and Hull TV. My name is Laura Tamblyn-Watts, and I'm a Senior Fellow at the Canadian Centre for Elder Law. And on the hot seat today, we have Ian Hull, co-founder of Hull and Hull, and we have Suzana Popovic-Montag, who's the managing partner of Hull and Hull. For those of you who follow the series regularly, you realize that mostly Suzana is the interviewer, but this time I wanted to put them on the hot seat. And the issue today we're talking about is something we've touched on previous episodes. The question of misdiagnosis of capacity, particularly with older people. So we know capacity is an issue. We know we can't assume that capacity is an issue. But we also know that other things look like capacity challenges. And that's what I want to talk to you about today. So Ian, have you seen this in your practice?
Absolutely. And, I use the mantra a little bit from time to time about probe and verify, but I get bamboozled all the time in terms of clients who come in who are presenting well, and I am simply not taking the time and paying attention enough to really the underlying abilities that they have in terms of capacity, not just ability to understand a financial statement, the ability to understand exactly what is going on and what they're going to get themselves into or what kind of estate planning they're going to get themselves involved with. And I am constantly reminding myself to probe and verify and dig deeper into what is being engaged in what looks like a very social and sensible discussion.
And if you're having that challenge, imagine most people who don't specialize in this practice area. So we have older people who present well, who have great social manners, but may not actually be able to quite grasp it due to a capacity problem. But how do you find out if it's really a mental capacity problem or just a passing concern? Suzana, in your practice, have you seen things that looked like capacity problems, but actually the person was fine? It was situational or health?
Many times we see that actually, Laura, and we're lawyers and we're dealing with somewhat of a medical issue when we're talking about capacity, right, whether or not someone is capable at law. And so we have, here in Ontario, the benefit of the Substitute Decisions Act, and we've got a test that we can apply in certain situations. But again, it all comes back to the fact that we're not doctors and we are dealing with someone in the moment and we are making situational assessments that may or may not be accurate. And so the system sort of provides us with a buffer of being able to rely on the medical professionals. But at the end of the day, the buck stops with us when it comes to whether or not we've done what we need to do as lawyers.
So the medical information is really evidence. It's kind of a piece of the pie. When you're trying to suss out or probe to see if the person may in fact have a dementia or other capacity issue, how do you go about doing that? What are some of the skills that you need to employ? Suzana, you've said that you've had people come in and you're wrestling with the medical piece. It's a delicate conversation. How do you do that?
Absolutely. I mean, you really gauge the situation, I think, and the individual who you're speaking with. And so you try to tease out of them if you've got any concerns. All you can work with is what they're giving you. But if they've given you something that you think, well, wait a minute, that's just a little bit odd, let me take that into a little bit more of an analysis, then that's the way that I do it myself. And how about you, Ian?
Well, I think one of the things that I do not shy away from is asking the tough questions, because that brings out almost every other angle that you can think of in terms of teasing out capacity issues. When you ask tough questions, that cognitively is going to be a test for them at that moment in time. And, I try to remind myself as I'm in situations where I've got a gray area client in terms of capacity, and I think to myself, don't forget, Ian, you're going to be judged. You're going to be judged by your peers, because if the question of capacity becomes scrutinized later, you're going to be judged by your peers. And most importantly, you're going to be judged by a judge. And I don't want a judge saying, Hull, you were lazy and you didn't take the time to take the extra steps or to ask the tough questions. So I always circle back to, at the end of the day, it's better for the client if I'm being more careful, but I don't forget my sort of circumstances surrounding those questions.
So you can kind of clothe yourself in your professionalism a little bit. There's the idea of, I'm a lawyer, you're a client. We have to ask questions in that relationship, which is different. And sometimes that's a way for family members to feel more confident as well. They may be concerned that mom or dad is having a capacity problem, and because of their relationship, they can't get into some of those tough questions. But actually taking the client to a different relationship allows those deeper, more probing questions to be drawn out. One of the things I want to just touch on, building on that, is the differences perhaps that you may have seen between what I will call a fundamental capacity problem So a dementia is a declining disease. You're not going to get better if you have a dementia. And we know that statistically about 1 in 2 people over the age of 65 has a dementia. And what we know less is that 1 in 5 people over the age of 65 have a dementia. We don't talk about that number very well. And that's a lot of our clients between 65 and 85. So 1 in 5. Right. But understanding that, how do you differentiate between a person just feeling uncomfortable or traumatized or in a difficult situation or not understanding something from having a dementia? How do you draw that line, or how do you tease that issue out?
Well, one of the things I get into the mindset, and I think of life experience are what can build your practice stronger and stronger. And I think of the tough questions I get asked by my doctor once a year when I go in for my physical. And they're not tough questions, but they're questions that are personal that you do not want sort of broadcasted sometimes. And I think to myself, if I don't get my client in that same mindset, then they're not going to be as engaged in this process. And if they're disengaged and they just simply want a cursory interview with me, and they're going to get cursory advice. And so I'm not afraid to push back and say, look, there's no problem. If you don't want to tell me about the nature and extent of your assets, I'm going to make a note in this letter, and I'm going to write you and say you wouldn't tell me, and you think it's that personal, and I'm going to give you that level of advice. And that almost always brings them back to, whoa, okay, you're right. You know what? If I want my doctor to be checking if I have cancer, I have to answer these tough questions. And if I want a proper estate plan, I have to answer these questions.
That's really important. Suzana, when you've seen folks come in, maybe there's cultural issues to having some of these conversations. They can look like capacity problems, but we've heard some people may have cultural concerns about talking about finance. Are there other concerns people don't like to talk about that may smack of a gray area? You don't know whether or not they are hesitant or incapable?
There's lots of areas like that where you find that you're probing, as Ian uses the terminology, and we're very careful that people understand why it is that we're doing that. And I think having that conversation, explaining to them, from our experience as litigators, that if you don't give us this information, you're going to get, as Ian said, cursory advice. You're not going to have as bulletproof a plan or a will as you might have otherwise wanted. I think that's the kind of stuff that helps underscore that importance to them. And then suddenly you'll find, in most cases, that they're a bit more free-flowing.
So the take-home message is threefold. First, set the stage, it sounds like. Tell people this is a special relationship that we're having. I'm not just being nosy. Second, that I have the responsibility to ask those hard questions. And the third is you get the benefit back from me doing it, that you get in and you get out. And out of that, what I hear you saying is that teasing and probing piece can really raise some red flags around what's hesitancy and what's problem of understanding. I wanted to thank Ian and Suzana for joining us in our conversation today. I'm Laura Tamblyn-Watts. Thanks for joining us for Hull & Hull TV.